This channel does not promote any violent, harmful, or illegal activities. All content provided by this channel is meant for an educational purpose only.
After my learned friends, Maharaj, the detailed, exhaustive, and learned presentation, Maharaj, I'll try and add a bit of my wisdom if I have left any, Maharaj. But on his wisdom, Maharaj, we'd rather rely on your wisdom than theirs.
No. It is the collective wisdom of all.
Now, Maharaj, let's briefly, Maharaj, what my submission is going to be. And it's going to be, I'm not going to repeat anything that my learned friend has said. Maharaj, what is PMLA? PMLA is a statute which empowers certain officers who are authorized under the statute to investigate. That's the PMLA. Nothing more than that. So every officer so authorized is empowered statutorily to investigate an offense. This is true, Maharaj, of all investigating agencies which are authorized to investigate under a statute. It is true of the code. It is true of CBI. It is true, Maharaj, under the Drugs Act, NDPS. So there's an authorization by the statute. So fundamentally, there can't be a fundamental right in these officers. No officer has a fundamental right to investigate. Right? I start with that proposition. Now, let's look at the statute so that we know, what the extent of rights are. Kindly have a look, first of all, at the definition. Section 2, clause D, small a.
Section
2, clause D, small a.
Yes.
Authorized person means an authorized person as defined in clause C of section 2 of FEMA, which my learned friend pointed out, Maharaj, at the beginning. Then kindly come to, before that, 2 small c, assistant director. Means an assistant director appointed under subsection 1 of section 49.
Yes.
Then kindly come to 2 small j. Definition of deputy director. Means a deputy director appointed under subsection 1 of section 49. Then come to the definition of director, 2 small k.
Yes.
Director or additional director or joint director means a director or additional director or joint director, as the case may be, appointed under subsection 1 of section 49. Right, Buzz?
Yes.
Now kindly straight away come to section 40, and I'll come back. The PMLA is not an authority under the Act.
Yes.
PMLA is no locus, as far as this Act is concerned.
Yes.
There shall be the following classes of authorities for the purposes of this Act. What are those? Director, additional director or joint director, with reference to 2K. Deputy director. Right, Malas? With reference to 2J. Assistant director with reference to 2C. And such other classes of officers as may be appointed for the purposes of this Act. So they are investigating officers. An investigating officer has a right under the statute to investigate. He has no fundamental rights. Now, what is he to investigate? Kindly come to 2 small na.
Yes.
Investigation, I'm sorry. Investigation includes all the proceedings under this Act conducted by the director or an authority authorized by the central government under this Act for what? For the collection of evidence. So that authority authorized, well, you go back to 49, as I indicated to your lordships first. So that's the investigation to be done under this Act. Right? Now kindly come to 2 small s. Definition of person. Person includes an individual. And the reason why it is defined is because they want to circumscribe the powers of the director, deputy director, assistant director to entities defined in S. You can investigate a person, an individual, an HUF, a company, a firm, and an association of persons or a body of individuals, whether incorporated or not, societies, right? Whether incorporated or not. Then let's kindly come to the definition of 2U, proceeds of crime.
Yes.
Proceeds of crime means any property derived or obtained directly or indirectly by any person. That's the definition of person I just gave to your lordships in 2S. So if a body corporate, an individual, or any of those persons, HUF, derived or obtained directly or indirectly by any person as a result of criminal activity relating to a scheduled offense. Not any offense. Scheduled offense. Or the value of such property, or where such property is taken or held outside the country, then the property equivalent in value held within the country or abroad. So they are entitled to investigate proceeds of crime in respect of a scheduled offense. And your lordships will see the scheduled offense is set out in the schedule itself. Right? There are any number of offenses that are set up. We won't go into that for the moment. Then property. Property means any property or assets of every description, whether corporeal or incorporeal, movable or immovable, tangible or intangible, and includes deeds and instruments evidencing title to or interest in such property, assets of whatever nature. And then the offense, is defined in 3. Right? So, I'll just read it. Whoever directly or indirectly attempts to indulge or knowingly assists or knowingly is a party or is actually involved in any process or activity connected with proceeds of crime. Proceeds of crime must relate to a predicate offense, a scheduled offense. If there's no scheduled offense, there'll be no proceeds of crime, right? Including its concealment, possession, acquisition or use, and projecting or claiming it as untainted property shall be guilty of the offense of money laundering. Then an explanation is added, and the word or and the word and is changed to or. If you'll see, look at the definition. In the main part, it is claiming it as untainted property shall be guilty of offense of money laundering. And then, kindly see the explanation. It says, for the removal of doubts, it's hereby clarified that the person shall be guilty of money laundering if any person is found to have directly or indirectly attempted to indulge or knowingly assisted or knowingly is a party or is actually involved in one or more of the following processes or activities connected with the proceeds of crime, namely concealment, the same word as in the main section, possession, acquisition or use, and projecting. Instead of and projecting, it says or claiming as tainted property. or projecting instead of and projecting. So they changed the explanation, doesn't matter. We're not concerned with it. We're not concerned with that. Now let's kindly come to section 16. Now 60 is the power to issue summons. Or assist you with the power to have a survey. Notwithstanding anything contained in any other provision of this
60
act.
is attachment.
16.
But 16.
16.
Yes.
Power of survey. Notwithstanding anything contained in any other provisions of this act, where an authority, and that authority is defined, director, deputy director, assistant director, and all others authorized for us. On the basis of material in his possession has reason to believe, the reason for such belief to be recorded in writing that an offense under 3 has been committed, he may enter the place. So much as the power of survey, that's not a fundamental right, that's a statutory right. Right? Well, he's entitled to do that. No issue on that. But then there is we're ad item on that. We're not questioning the power of the authorized person to come and do what they have to do in terms of the statute. The question is they have no fundamental right. That's the issue, because this is a 32 moved under 32. Then search and seizure. Again, where the director, section 17, where a director or any other officer not below the rank of deputy director authorized by him for the purposes of this section on the basis of information in his possession has reason to believe, the reason for such belief to be recording in writing, that any person, that person is 2S, which I read to your lordships, then they can actually search and seize. Again, regulated by law, regulated by the statute, right? Unless to this extent, it is different from the Code of Criminal Procedure, because the nature of search and seizure under the code is somewhat different. Now, let's slightly come to, then they can retain the property, we're not concerned with it. Then let's kindly come to section, then 48 I have read to your lordships. Then kindly come to section 49. I read 48 to your lordship, now 49. So the central government may appoint such persons as it thinks fit to be authorities for the purposes of this act. So the power is with the central government to appoint persons under the statute to carry out the purposes of the statute. And to that extent, it's a regulatory statute as well as an investigative statute. Then section 50. The director shall, for the purposes of section 13, have the same powers that are vested in a civil court under the code while trying a suit in respect to the following matters. Again, power of discovery, enforcement, enforcing the attendance of persons, including officers, of a reporting authority. The reporting authority here are banking authorities. We're not concerned with that. Compelling production of records, receiving evidence or affidavits, issuing commissions for examination. So your lordships will notice that the entire petition contains that this is the officers who went there under the statute and they wanted some documents. They wanted the production of some documents. Those documents were taken away. That's the tenor. But that's nothing to do with the fundamental right. I don't know how the fundamental right comes into the picture. Where none of these authorities which have these powers under the statute have a fundamental right for this. They have only statutory rights. Now, let's kindly see further. Then, subsection 2. The director, additional director, joint director, deputy director, or assistant director shall have power to summon any person whose attendance he considers necessary, whether to give evidence or to produce any records during the course of an investigation or proceeding under this act. Now, your lordships put the question to us, if somebody obstructs such a proceeding, what is the remedy? Well, there are remedies available under the BNS itself. There are remedies available under the law. The remedy is not a writ petition. under 32. Because what are you trying to enforce? Not anybody's fundamental right. These are statutory powers given under the statute, brothers, and it's regulated. Their powers are regulated. Now see further. So give it. All the persons so summoned shall be bound to attend in person or through authorized agents, as such officer may direct, and shall be bound to state the truth upon such subject, any subject respecting which they are examined, or make statements, and produce such documents as may be required. Every proceeding under subsection 2 and 3 shall be deemed to be a judicial proceeding within the meaning of 193 and 228 of the Penal Code, and subject to any rules in this behalf by the central government. Any officer referred to in subsection 2 may impound or retain in his custody for such period as he thinks fit any record produced before him in any proceedings under this Act. Then let's kindly come to jurisdiction of authorities is 51. The authorities shall exercise all or any of the powers and perform all or any of the functions conferred on or assigned as the case may be to such authorities by or under this Act. There is no power outside this Act, brothers. So which is the fundamental right that they are claiming? Forget about, brothers, the larger issue of 131 and the central government and that this doesn't have any corporate personality. Forget that. Under the statute itself, none of these authorized persons have a fundamental right. And if they don't have a fundamental right, certainly the enforcement director doesn't have a fundamental right. The enforcement directorate, has the central government appointed these officers. Now, see further. So I was reading, the authority shall exercise all or any of the powers and perform all or any of the functions conferred on or assigned as the case may be to such authorities by or under this Act, or the rules framed thereunder in accordance with such directions as the central government may issue for the exercise of powers and performance of functions by all or any of the authorities. Now, the issuing of the directions or orders referred to in subsection 1, the central government may have regard to any or more of the following: territorial area, classes of persons, classes of cases, and any other criteria specified by the central government. That's also under the Act. Then power of the central government to issue directions. The central government may from time to time issue such directions, instructions, and directions to the authorities as it may deem fit for the proper administration of this Act, and such authorities and all such persons employed in execution of this Act shall observe the follow such orders, instructions, and directions of the central government, provided that no such orders, instructions, or directions shall be issued so as to require any authority to decide a particular case in a particular manner or interfere with the discretion of the adjudicating authority in exercise of its. And then 53, the central government may by a special or general empower an officer not below the rank of director of the central government or the state government to act as an authority under this Act. Even a state government authority, can be so authorized by the central government to act under this Act. And then certain officers to assist with the officers of custom, that's 54. And thereafter, you have 63. Punishment for false information or failure to give information. So if somebody fails to give information, there is a punitive section. Any person willfully and maliciously giving false information or so causing an arrest or a search to be made under this Act shall on conviction be liable for imprisonment, which for a term which may extend to 2 years, or with fine which may extend to 50,000 rupees or both. And if a person legally bound to state the truth of any matter relating to an offence under 3 refuses to answer any question put to him by an authority in the exercise of its powers under this Act, or refuses to sign a statement by him made in the course of any proceeding which an authority is legally required to sign, to whom a summons is issued under 50, either to attend or give evidence or produce books of account or other documents at a certain place and time, omits to attend and produce books of account or documents, he shall pay by way of penalty, and if he doesn't follow it, then a prosecution will be launched against him under subsection 4. 174 is the section. So the scheme of the act is that it's a regulatory statute with investigative powers, where authorized persons whose powers are, the contours of whose powers are controlled by the statute. It's like saying, well, it's election law. Nobody has a fundamental right to fight an election. These are all statutory rights. So, the first question that your Lordship,
Fundamental right is to fight outside.
that also we have no fundamental right. We have a fundamental right, Mullahs, to keep peace. Anyway, that's our duty. So, Mullahs, the schedule that your Lordships will see is that page 51. Offenses. This is, unless there's a predicate offense, this ED doesn't come into the picture at all. What does that mean, Mullahs? First, an FIR is to be filed. Then the ED comes into the picture. Otherwise, ED doesn't come into the picture. Now, there's no FIR in this case, right? They have come under 32. Under what provision of law have they come under 32? Neither the statute allows it, nor the Constitution allows it, nor Part 3 allows it. But their purpose is not that at all. What they are claiming in the petition is, please ask the CBI to investigate this. But the ED can't ask that. ED can't ask the CBI to investigate Mullahs.
No, it is not the offense under PMLA which the CBI will inquire.
Of course they are inquiring. They went there only for that.
You must consider and keep in mind that everything is in relation to that incident.
I'm coming to that.
But I'm making it clear, we are not asking that CBI should investigate PMLA offense.
It's not that.
What PMLA
The offense is committed by the Honorable
PMLA
Chief
offense.
Minister
Did I say
and others.
PMLA offense? Did I say PMLA offense? A scheduled offense.
It is.
You are
Not even scheduled offense.
One-
Yeah. Anyway, we will.
Let's just hold on. hold
None
on.
of these.
Unless
would
there
be
is a
relevant.
predicate offense, the ED doesn't come into the picture. The ED does.
It is quite this particular incident of the Chief Minister.
Where's the scheduled offense? Where's the scheduled offense?
It is not about scheduled offense.
Then what
It
is
is the offense. These are 4 offences which you have registered against them. Yes.
That's a different. Our
No,
offense.
no, that is the only thing. What they have come.
No. Mullahs, the petition. I'm sorry. Then obviously, Mullahs, your lordships have not seen the prayers in the petition. Not that at all.
Let us read again together.
Yes. Of course.
It is not for any offence under PMLA which they have come here.
Not PMLA, Mullahs. Not PMLA.
Yes.
Not
And you are
PMLA.
showing the entire PMLA Act and the scheme of the Act.
The scheme of the act,
But-
meaning that they have no fundamental right to invest. They have no fundamental right to invest. But let's see the petition. It's better.
Yes. So what we have understood is,
Yes.
on a reading of the petition is that
Yes.
the officers of the ED are claiming fundamental right where their safety while investigating the offense,
Yes.
that is only an incident of investigating an offense. But their main plea is that while investigating the offense under PMLA,
Yes.
they have been threatened.
Correct.
They have been threatened.
Correct.
And they have committed the offense intimidating itself.
Sir, allow me. What's the fundamental right there? Assuming they have been threatened. What's their fundamental right?
So that they will answer.
I'm sorry. No.
They
I'm
will answer.
asking myself the question. No, Mullahs, what's that fundamental right, Mullahs?
No,
Kindly see
we
the
will
BNS.
answer at the end, not now.
Let's see the BNS, Mullahs. Very simple, Mullahs. The answer is here.
Yes.
Kindly see. Kindly see section 221 of the BNS.
No, let us first read the relief.
We'll see, Mullahs, but since your lordship asked me this question, that look, they are wanting that nobody should interfere, the BNS has the answer.
Yes.
BNS obstructing a public servant in discharge of his public duties, functions. That's the answer.
Now,
It's an
let
offense.
us read the prayer.
Now let's see. Page 40.
Page 46.
Let's see the prayer. Let's be clear, Mullahs, let's see what they are asking.
BNS.
issue a writ of, I'm sorry, page 46.
Yes, yes.
Issue a writ of mandamus directing the CBI to register FIRs. Here it is, Balaritan says nothing, has nothing to do with CBI. It's here it is. Register, directing the CBI to register an FIR. How can ED ask for that? And investigate the entire incident in relation to obstruction of ED's search conducted on 8/1/26. The answer is in BNS. At both the residential premises of one Patik Jain, as well as the office of Indian PSC Consulting Private Limited, described in detail above, including the role of the respondent number 2 being the present Chief Minister for whom I am appearing, the Commissioner of Police, Calcutta, the Director of General of West Bengal, and all persons acting in concert. So they, Malaj, thwarted the attempts of the ED
In this where is the scheme of PMLA coming into?
because they can't ask, ED can't ask the CBI to investigate. This is to be a separate predicate offense.
It's not a predicate offense at all, my dear sir. It is not a
If you
predicate
don't
offense.
mind, unless there is a predicate offense under the code, now under BNS, ED cannot come into the picture. That is settled law.
ED
by
as
this
an
court in
investigative
several-
agency-
ED cannot file a writ petition for their fundamental right. They have no right to file a writ petition to have the CBI lodge an FIR.
Mr. Sibal will continue on Monday.
Yes,
Please,
that's
sir.
fine.
Please, sir.
Yes, that's fine. Yeah. It's miscellaneous, but it's miscellaneous.
Tuesday, you wanted to, because
Tuesday.
Tuesday would be better.
Wednesday, my lords, then
No, Wednesday would be, you see,
Thursday, whatever suits my lord.
No, Tuesday, Malaj.
any last working day became before long holiday.
No. We also want a holiday. You want to work on the last working day. But
23rd.
Tuesday is fine. Tuesday.
No, judges,
Tuesday is
it
fine.
is, though this 23rd,
Tuesday is fine.
25th is Wednesday, but for
20
being the last working day of,
Tuesday.
I like Friday.
Tuesday, Lord, Tuesday.
Tuesday, my lord.
Ah, Tuesday.
Tuesday,
We are at item that 25th is not the correct day. We are at item.
How, Mr. Syam Diwan,
Tuesday, Lord, Tuesday.
Tuesday.
and
Yeah.
just 1 minute, Mr. Syam Diwan. Kapil Sibal is yet to conclude his arguments. Post the matter on Tuesday as part heard. We'll take it Tuesday.
Tuesday, Lord. Grateful.
Grateful, my lords.
Obliged.
Item 19, whatever date in all other matters, whatever date suits to learned advocates, they may take whatever
There
they
is- In one matter, there is an interim relief till today, maybe extended.
Interim relief granted.
Item number 19, I will take it just on Tuesday, Marad.
Tuesday, it will not happen.
It won't
Don't take
come.
unnecessary, knowing fully, all, you see, big guns are going. You think it will be.